Phillipsburg Town Council meeting, December 20th, 2021. In this video, you will hear Attorney Wilhelm, the Land Use Board Attorney for Phillipsburg, New Jersey, explain why the Land Use Board is moving a meeting to review the Consistency Plan report to December 20th, 2021 from January 27th, 2021. On December 16th, 2021, Attorney Wilhelm said that because of the need to provide proper public notice that the public hearing on the consistency plan for the Perone project was being moved to January 27th, 2021. Perone Corporation threatened Attorney Wilhelm with a lawsuit and said that the actions being taken by the Land Use Board did not require notice for a public hearing and a consistency report. Attorney Wilhelm consulted with the Land Use Board Chairman, Bill Duffy, regarding the issue. In spite of the fact that Attorney Wilhelm believes that the claims made by Perone Construction's legal team are frivolous, Bill Duffy decided that the town should not provide what Attorney Wilhelm believes is proper public notice and fold to Perone Construction's threat of a lawsuit and the legal team from Florio Perucci, Steinhardt, Capelli, Tipton, and Taylor's demands. Does this mean that any applicant that is in the same type of situation before the Land Use Board, such as Perone Construction is now, can now threaten a lawsuit and cause the town to deviate from what the Land Use Board attorney believes is the correct legal process?
I'd like to have a motion for the planning board to have an emergent meeting.
So moved.
Mr.
Second.
Fulper,
Yes,
do
sir.
I have a second?
Second.
Who was that?
Mr. Hardisek.
Jim? Okay. Okay. Scott?
Yes, Mr. Duffy, the need for an emergent meeting is found under NJS 10:4-9B1, which says, quote, such a meeting is required in order to deal with matters of such urgency and importance that a delay for the purpose of providing adequate notice would be likely to result in substantial harm to the public interest, end quote. Now, to further explain the rationale here, the substantial harm to the public interest is the December 17, 2021 letter from Perone's attorney, which has expressly threatened to sue the Land Use Board attorney for what he characterizes as, quote, deliberate and willful misinterpretation of the law, end quote, because the applicant's attorney disagrees with the Land Use Board's attorney's interpretation of the law as to whether, one, Phillipsburg Town Council's Ordinance 2127 is a purely developmental regulation under the New Jersey Municipal Land Use Law, NJS 40:55D-26A, which is referred to the Land Use Board for consideration of its consistency with the town's master plan without the Land Use Board being required to give notice of the hearing date or to allow public comment. Or alternatively, two, if Phillipsburg Town Council's Ordinance 2127 is an amendment to a redevelopment plan under the New Jersey Local Redevelopment and Housing Law, NJS 40A:12A-1 et sec. If it is the latter, an amendment to a redevelopment plan, then public notice of the Land Use Board's review must be given pursuant to NJS 40A:12A-6A in the manner prescribed by NJS 40A:12A-6B3D. If it is the former, a purely developmental regulation, then public notice is not required. As the board attorney, I believe Ordinance 2127 is an amendment to a redevelopment plan for at least 5 reasons, including the following. 1, the ordinance, written and adopted by the town council, is captioned, quote, an ordinance of the town of Phillipsburg, County of Warren, New Jersey, adopting the District 5 Riverside Industrial Amendment Riverfront Redevelopment Plan, end quote. 2, the body of the ordinance states multiple times that its authority is based upon the New Jersey Local Redevelopment and Housing Law, NJS 40A:12A-1, and does not cite the municipal land use law at all as a basis for its authority. 3, in the last whereas clause of the ordinance, the town council expressly states the following, quote, "This ordinance shall nonetheless be referred to the land use board for review anew pursuant to NJSA 40A:12A-7E," end quote, which is the local redevelopment housing law, and which states, quote, "Prior to the adoption of a redevelopment plan or revision or amendment thereto, the planning board shall transmit to the governing body within 45 days after referral a report containing its recommendations concerning the redevelopment plan," end quote. This part of the development statute must be read in conjunction with NJS 40A:12A-6, which states that a redevelopment determination shall be made after public notice and public hearing as provided in subsection B of this section, end quote. Number 4, in its now therefore clause number 2, the town council has expressly stated that its ordinance 2127, quote, "is hereby adopted pursuant to the terms of the redevelopment law," end quote, which of course means the New Jersey Local Redevelopment and Housing Law, and does not state its authorities based upon the municipal land use law. And 5, a reading of the entire ordinance illustrate that its authority is based upon the local redevelopment and housing law and not at all upon the municipal land use law. Accordingly, I advised the Land Use Board on December 16, 2021, that the referral could not be heard by the Land Use Board on that date because there was inadequate time from the date of the referral from the town council to the Land Use Board, which was November 24, 2021, the day preceding Thanksgiving, to provide the statutory public notice. The applicant's attorney disagrees with my interpretation, which is his right to disagree. While the applicant's attorney also is entitled to threaten a lawsuit, I believe such a lawsuit would be vexatious, harassing, patently frivolous, and devoid of merit. Nonetheless, in consultation with the Land Use Board Chairman, it was decided that the Land Use Board would grant the applicant's request for a special meeting on an emergent basis, because had the Land Use Board not granted the request and been sued by the applicant, there would be, quote, "substantial harm to the public interest," end quote, as the town taxpayers would incur significant legal costs defending the Land Use Board's attorney's reasonable interpretation of the town council's express language in Ordinance 2127 and application of the facts to this matter under controlling law. The Land Use Board does not wish to see such substantial harm to the public interest. When balancing the substantial harm to the public interest in defending against a frivolous lawsuit by the applicant versus the possible pitfalls in proceeding to undertake the review required by the ordinance on an emergent basis, the Land Use Board has decided that the public interest is better served by proceeding this evening. So now, Mr. Chairman, it would be appropriate to take a vote regarding the emergent meeting unless other board members have something they wish to discuss regarding this meeting.
Does any board member have any questions or comments? Seeing none, I'm going to ask for a roll call vote on the emergent meeting.
Okay. Mr. Hanasak,
Yes.
Mr. Penrose,
Yes.
Mr. Turnbull,
Yes.
Mr. Benjavanga,
Yes.
Mr. Foper,
Yes.
Mayor Trussigny.
Yes.
Mr. Swicker,
Yes.
and Mr. Duffy.
Yes.